May I be from rapport notice, my lord. This is a matter, my lord, suffering interim order. In a matter passed by the appeal has been filed miscellaneous appeal against the lower appellate court order of remand.
What?
There is a interim order is there on. So we are suffering that only for inclusion in the list, my lord, for bracketing.
Application.
Application filed.
Say that it is an application.
Application.
Give.
Gratefully, lordship.
And may I mention, may I have your lordship's kind leave to mention item number 62 if it can be taken up before the vacation. This is this interim order has been
This application or order 41.
order 41.
We'll take up. Don't worry. We are taking up order 41.
We are suffering an order of injunction. That is
Don't worry. Let us see. Let us see.
May I have your lordship's kind leave to mention a matter to be enlisted as to be mentioned, my lord, to be enlisted as to be mentioned, my lord, because my lord, the direction for filing paperbooks has been long over, my lord, nothing has been done. So, my lord,
Before the Lowajima court.
but
Why everything will come here? Go before the Lowajima court. That's the Lowajima court is meant for that. If the paper book is not filed within time, oh, they are just sitting idle. Nobody is going before it. They sit every day at 12 noon. Go there.
may I renew my prayer, and if it can be taken up tomorrow.
If you permit us to call the list, I think it will be taken. So just wait. We can.
My 63 at same period. If not, please can I come?
These will pick up. There are one yesterday could have been, but yesterday one matter continued for a long time. So we can't, because the bar really controls the argument. We can't have anything.
And we appreciate it.
I have kept this matter for one because I need that both of you should be more ready in the matter than arguing in a very truncated. Please read several judgments. You both of you know the characteristics. I always go and prepare myself.
Yes, my lord.
But I find there is a lot of gray areas in both. So I want everybody to address us. I told my brother, though we have one view, but I told that this is what I am facing. So you should be given a notice. There are 5 judgments of the Supreme Court and 6 judgments of the different high courts. One has to look. It's a very dicey question, I tell you, very, very frank. So I need both of you to do it.
Kindly keep it.
Any day, my lordship, subject to your convenient, my lord. Any day, subject to your lordship.
Just after the reopening,
My lord.
The only thing, kindly make it. Have you heard the matter?
it is already made CME, sir. So it will not go anywhere. The matter was kept. Matter was reserved for judgment.
You have to pay something. Hey, actor page. Supreme Court on the তুমি চাইলে তোমাকে দিতে পারে না তুমি
Plus points involved in the instance.
না না তুমি আমি আজকে
And invited the attention of the respective committees. This
Number 29.
chair
तो ऐसा है ठीक हम जो है
we fix.
civil appeal number
any day, my lord, subject to your convenience. 5th, 6th,
We are reopening on second.
second
my lord, 5th, 6th,
5th, what 5?
5th, my lord,
Messrs. Asian
5th, my
5th January.
5th.
हाँ टोटल कितनी
my lord के बोले थे no, my lord, I find the judgment. ভার্সেস আমি দিয়ে দিচ্ছি হোয়াটসঅ্যাপ করে দিচ্ছি মানে though my lord 2023 my lords justice Oak holds in my favor
2023, my lord. Justice hold in my favor.
There is another judgment against.
My lord, that's the reason I say that my lord has granted us time.
That is a division which I have come across with their judgment.
My lord, that's true.
This judgment.
That's true, my lord. ওটা দেখো, ওইটা কোনোদিন না হলে ডায়রি আমি খাতাটা
Rastriya Spark judgment.
my lord, that's old.
I have seen, but there are some gray areas.
Your lordship, from your lordship book, my lordship can.
Why should you?
We will study.
My lord has a book. I know that, my lord. We can copy that. We can be helpful for us. Very helpful for us. My lord, no, my lord, খাতাটা যদি পেয়ে যায় তাহলে দিয়ে দেয় তাহলে আমি grateful.
We can bind your lordship's khata. Your lordship can.
Which we bind sir also. The lordship copy binds. I'm grateful. I'm grateful. Last one.
May it please my lords. My lord, this is my appeal arising out of an order. It had appeared on extension of interim order. My lord, the order was passed on the 11th of October. 10 weeks. My lord, it's set to expire tomorrow. Yes, my lord, I have served. May I hand up my affidavit of service, my lord? My lord will see there are 3 addresses. One is received.
Item. Insufficient address.
On 2 addresses, my lord, it has come back as insufficient address. On 1, it is duly delivered.
Let the affidavit of service right to be kept on record. The interim order granted earlier is extended for a further period of 8 weeks from it or until further order is given. The affidavit is directed to communicate this. This is the matter. 1 week after the yes.
My lord, 1 week after the vacation, extremely obliged. With my lord's kind leave. I will, my lord, as of today itself, my lord. Today itself, my lord. Extremely obliged.
No, October. Who's more orders?
Lordship, my interim order will expire, Lordship.
We will see. When will you expire? We will extend it.
Yes, it has expired yesterday.
Yesterday. Which one?
Lordship, item number 5.
Just give it for extension tomorrow.
Lordship.
Item number 3. 3 days before the vacation. So I do not want that every heavy matter should be taken up.
The part में लिखे तो lordship लिखे
What?
part
Nothing to worry.
मतलब worry is lordship मतलब will also
Worry.
मतलब being a junior member of the bar मतलब praying before your lordship.
No, nothing to worry. Mr. Mukherjee, can you spare us? Mr. Mukherjee, can you spare us? Because
Two are not sparing your lordship, I'm sparing myself. Only thing I was worrying about, my lord, I think your lordship will be continuing the same bench.
but that's why your juniors apprehended. I said nothing.
I have understood it. Nothing to worry about.
Yes. Yes, yes. Come. Mr. Mukherjee, come after vacation.
Grateful also.
And enjoy the Christmas.
Well, I can't wish the same to your lordship, but I wish your lordship all the best.
Uh.
All the best.
Thank you.
Well, let it retain its position.
Oh, it will. Yes.
Balaji ke phone karo.
Our last occasion, my lord was pleased to submit me the information whether the respondents were appeared in the suit or not, my lord. Well, this is the information slip. They have appeared all along, my lord. Second.
Last question. So they appeared.
Yes, my lord.
So can you serve the lawyer?
My lord, if you, my lord.
Yeah. Yes. Lako, it is submitted by the learned advocate for the appellant that the respondents have entered appearance before in the trial court, but they are avoiding the service as directed by this court in the instant appeal.
My lord, I have served, my lord.
Anyhow,
Yes.
in view of the above, and in order to obviate any difficulty in future, we direct the appellant to serve a copy of this application upon the learned advocate representing the respondents in the trial court. Yes. Indicating that this matter would be listed on 4th January.
My lord, kindly give me one more week, my lord. My lord, it is at Malda, my lord.
11th.
Yes.
11th January 2024.
Great.
Yes.
13 Milord, Mr. Onil Chatterjee is the leader in the matter, Milord. I'm paying for notice.
Every time accommodation is sought since last week.
Milord, for the
Then
personal.
what is the reason for keeping all these matters? Let it go out of place and
Milord, kindly make
because
it
it's the order
notice.
41 of 2023. You do not want.
But for the personal difficulty, Milord, he has not come to court today, Milord.
Not this week.
I'm so pleased.
Spill over to other side of the vacation. Yes, call. Hey, Sono, do one thing. 14, nobody appears. Not this week. So that at least we can decongest the list. Not this week. Okay. Some not this week.
Item number 18, praying for time.
Not this week.
Not this week.
Yes, be happy. No, no. On this week, just note. No.
Kindly make it up. Immediately. Like that Andhra judgment.
Why? Hey,
Andhra judgment.
Chamber. Let us see money. Let us see key denote कर. Signature बाकी नहीं पूछते बच्ची S वाले. ये signature पर. ये तो C can. E. Yes, भाई बोलो चेम्बर. Yes, yes, not this week. Happy?
Immediately on we are putting.
Not this week means what?
As well. Just we want to go through. We're going through that. The last day I got the copy of Hyderabad judgment. Andhra judgment.
Yes. Next.
The 33 minute, the matter has already.
For the respondent.
I am for the appellant. But the matter has already been settled in before the court below. My client has come, she will sign the person who has filed the appeal, but she has already written the letter. I am just making a photocopy and I will hand over to your lordship. My client don't want to proceed with the matter. Matter has already been settled.
Where is the order?
No, it has been settled amicably, my lord.
Suit is pending. Suit has gone. This is the second appeal.
A compromise petition is before your lordship in the court below.
But why the second appeal then?
Second appeal, my lord, what happened in the execution proceedings? My lord, there is a third party filed an application, my lord, that was registered as miss case. Now all the parties have settled the matter between them in the court below. Now my client don't want to proceed with this appeal.
Advocate and record.
So, she is.
The learned advocate and record of the appellant submits on instruction he received from the authorized person of his client, being one of the appellant herself.
No, my lord, what happened, my lord, this appeal was filed through the power of attorney. That power of attorney has already given a letter to us that he don't want to proceed.
Through authorized person. That the appellant does not intend to proceed with the instant second appeal as the parties have amicably settled the disputes out of court. In view of the above, the appeal is dismissed as not pressed.
Madam, within 5 minutes, madam, I'm filing the instruction. Madam.
If you file, then one line will go that let the written instruction be kept on.
Great.
ठीक है जी, यदि वो फाइल करे
It is the name like
Lordship, I was for item 30, my lord. Actually.
Do it. You want to do it? Argue?
Actually, my senior is in stuck in
Then, sorry, then not this week we have done. We have not dismissed anyhow.
41, my lord, I am appearing for the petitioner, my lord.
What is the defect?
My lord,
What is the defect?
my defect, my lord, the suit is not maintainable.
Sorry? The appeal is shown defective. What
Yes.
is the defect in the appeal? I just wanted to know.
My lord,
Have you gone through the memorandum or file?
no, my lord.
Did you not notice that there is a reflection that the appeal, there is a defect? It says defective. Look at the list.
No, my lord, I did not see the list, my lord, as defective, my lord. I'm praying apology for this, my lord.
Nowadays, nobody cares. When you notice that the department has said defective, then at least you should go through the file and find that what are the defects in the morning. It is every time the court will look into it and then tell you that what is the defect. देखिए, out of time, sir. Section 5
Section 5, my lord.
has been filed or not?
Yes, my lord, I have filed the section 5.
Sir, there is another problem. The problem is that whether the appeal would lie. The suit value is 72,000 before the civil judge senior division.
Yes, my lord.
That's an original court. Will it lie to the High Court?
No, my lord, it will be detected by me thereafter, my lord. My lord, the appeal will not lie the dishonorable, my lord.
You have to go before the district judge.
My lord, I am praying, my lord, there is a limitation, my lord, I am praying for liberty to file the appeal, my lord. I have
Before
come.
the district judge without limitation. What are you talking? Is this a correct proposition of law? Tell me. Can the court pass an order that no limitation will lie? Because this is pandemic is another situation in a special leave petition. That's in the writ petition. But whether the appellate court can pass such an order, take an advantage of the other provision of the Limitation Act,
No,
apart from Section 5, another provision. The stamp reporter has indicated that the instant appeal has not only filed beyond the statutory period, but the valuation disclosed does not warrant an appeal to be filed. नहीं है, वो बेकॉल आगरा ना सा अरे अरे काज करो ना वेस्ट बेंगल এই এখানে হবে না ওয়েস্ট বেঙ্গল লজের ওখানে বলো ওকে বেঙ্গল আগ্রা আসাম সিভিল কোর্টস অ্যাক্ট না বেঙ্গল আগ্রা स्टाफ रिपोर्टर को before this court, if the judgment if the order / judgment is passed by the civil judge within the senior division exercising original jurisdiction, in view of the above, the appeal is not maintainable under section 21 within bracket 1 a small a of the Bengal, Agra and Assam Civil Courts Act. Full stop. The appeal is dismissed as not maintainable. However, dismissal of the appeal shall not preclude the appellant to assail the same order before the appropriate forum in accordance with the law. Let the certified copy of the impugned judgment and order be returned to the learned advocate and record of the appellant upon replacement with photocopy thereof. What করে দিও by ACO.
Grateful, my lord.
In view of the dismissal of appeal as not maintainable, the connected application is also dismissed as not maintainable. Now, is dismissed. Take
Grateful.
back immediately
Yes,
certified
ma'am.
copy. Otherwise, further limitation will run.
Yes, ma'am.
Yes, call the next.
I'm the petitioner in this case. Last occasion,
I'm only praying for a not today in this matter, millet, today, only for today, millet. 43 millet. I'm praying for the respondent.
that's one incident happening is that first week of December this year, they got married. That's I got some information, though I have no documents. And then July, I have filed the appeal and they got the petitions, copy of the petition on August. They appeared in October, despite the fact this is happening. So this is urgent. My lord, on the other day, Appeals Court decision was Appeals Court decision was known to us because by your lordship that even if he is married, then the case appeal may go and they will have to face the consequence of this. So in view of that, I am praying for if it is not today, then tomorrow if it is taken
Tomorrow, come
huh?
tomorrow.
Tomorrow, millet.
So that I am suffering over this.
Come tomorrow.
Grateful, millet.
At the top, if it's possible.
Yes, top of our name.
No.
Extremely grateful, millet.
But I beg to appear for the appellant, my lord. This matter was initially taken up on 11th when NN Global 2 was in existence. Subsequently,
Now 7 judges.
now I have the judgments, my lord. Only that was my saving grace, 13th of December, my lord. This matter was placed on 14th, wasn't taken up. I have got this. With regard to praying rejection of an order, thereby refusal to pass any ad interim protection in favor of the plaintiff.
Can you come tomorrow because we did not have a copy of the judgment.
May I?
So you give it. Let us go through the judgment,
my lord. My lord, since
Overview. This is from paragraph 37.
My lord. It even went to harmonious construction for those two sections and the reliefs, ultimate reliefs.
We come to know that
Hmm.
as far as agent number is void,
My lord,
that void has been
overruled.
Can't say void
My lord,
because the language is inadmissibility.
in evidence,
Inadmissibility of a document does not render the document as void.
my lord.
This is what
Even the act upon was elaborated in the entire judgment. The act upon part was even elaborated. Even the arguments were taken. Section 9,
whether section 36 was taken into consideration.
hello, section 36, 42 was taken into consideration. My lord. 36, as far as I have read, my lord,
It could see
it was, my lord.
36 was taken into
My lord, it was argued by the respondents in that maculative petition, and the arguments of the appellants were,
Self says that it cannot be void,
my lord,
nor can be said that it is inadmissibility. If you look at the spirit of section 36, it ruled out both the situations. Give one copy.
well, may,
You have the extra copy.
no, my lord,
No. Start that.
may I read, my lord? Argued.
36. See to yes.
My lord.
36 has been considered.
No, my lord, from what I have read, my lord, it was. Since the inference was drawn with regard to that part, that evident tendered in evidence, my lord. Evidentiary, it was, my lord. And it said that these provisions cannot be overriding on the protective measures. The Sultana Begum's judgment of 97 SCC was considered elaborately in this judgment.
Yes, let us
My lord.
that,
My lord, may I only pray one thing, my lord? Since this is with regard to refusal of an identity model, may I have an early audience tomorrow, my lord? Because so, may, my lord, I'm grateful, my lord.
Okay. वो जजमेंट 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 के साथ stand.
I'll make. Okay.
I am the appellant, my lord.
So,
I'm extremely sorry. I mentioned I'm led by Mr. Van.
My lord, this expression, my lord, what fell from your lordships regarding the pace of the bench, my lord, I was, my lord, talking to Mr. Obrotosh Mojumdar, my lord, regarding this, my lord, comment that fell from your lordships. Mr. Mojumdar told me, my lord, to remind your lordships of those days when my lord used to, my lord, spin bowl. But the matter, my lord, we mentioned, excepting this matter, that has also been taken up. And, my lord, it is proven that, my lord, we really underestimated. My lord, this is from, my lord, an order, my lord, allowing order 39, rule 1 and 2 application. So, my lord, I must serve notice and then, my lord, come back.
Order 7 to 11 gone.
Order 7, rule 11 dismissed. My lord, gone, yes. A single order covering both.
Oh, it covers both.
Both. My lord, from order 7, rule 11, we will be filing a revisional application. But the revisional application has not yet been filed, it's, my lord, in the pipeline.
For a dependent.
Yes. My lord, I have challenged, my lord, the injunction order here before your lordships and order 7, rule 11, my lord, before the revisional court, my lord, will be challenging. Because, my lord, part by part, the order has been passed. My lord, the first part takes care of orders. আরেকটা কপি ডিভিশন বেঞ্চটা
Why you have not filed a revisional application?
and I was even now inquiring.
Together, but you will be also taking up the abandoned.
Absolutely. Absolutely. My lord, in the meantime, my lord, we will take out that application. My lord, we will mention it before your lordship and also before, my lord, the revisional court. My lord, in any case, I cannot ask for possibly stay of operation of the order. My lord, I have learnt it from your lordship. Kindly, my lord, kindly allow us, my lord, to file supplementary affidavits only for this purpose. My lord, the documents annexed to the plaint are inadvertently not annexed to the can. And only those. Wait. So grateful to you. So grateful to you, Lord. Great. Great.
But I appear for the respondents 2 to 6. But if your lordship see one, but there is a delay of, according to me, 10 days. According to the stamp reporter, it is 18 days. But delay I have stated stamp reporter.
Yes. FMA.
Is now, my lord, if your lordship see once, this is the
Injunction, sorry.
injunction. FMAT.
My lord, kindly comes to.
18 days.
My lord, delay I'm not opposing. I cannot also, my lord.
Let us dispose of.
Absolutely. My lord.
For condition of delay. I think
Now, my lord, yes, kindly see, my lord, page 36 of that stay application.
Your lordship's earlier.
Yes, kindly,
Your lordship's earlier order, my lord, the same stand has to be.
kindly see once, kindly.
That is my order.
Yes, sir. But trial court now refuse that.
Don't deny. Sometimes
I
he
know.
may commit some mistake.
No, my lord
No, no.
will only see.
দাঁড়া দশটা বলবেন দশটা মিস্টেক করেন না বিশ্বাস করতে হবে I don't know what happened, my lord. If your lordship kindly see the facts. But if your lordship kindly see, my lord, page 36. The facts, my lord, your lordship will gather from your lordship's own order.
Oh, that was the situation where even after granting a leave under section, the court says I will not pass an order because
And
notice has to
yes.
be given under section 8.
Absolutely.
So,
Now, on the basis of
we have hit the other page and said that no, once you granted a leave, then there is
Automatic.
no matter on the part of the court to consider the prayer for
Yes.
that.
now kindly
That does not mean anything.
no
No, my lord, the
latter part.
relevant portion is paragraph 7 and 8 of your lordship's order.
সেটাই আমি বলছি kindly go through the latter part.
What?
Your lordship has seen, my lord, up to, my lord, paragraph 5. Kindly see paragraph 7 onwards.
Yes.
Now what happened after your lordship's order? They filed objection. Now this time learned trial judge refused to pass the ad interim order. The reason has been stated without evidence. This cannot be decided. Although they stated that they will not touch. Now the observation, although it is not recorded, but I think from the bar I may say that you did not obtain any injunction from the High Court. Therefore,
No, we refuse to pass an ex parte
on in view of their absolutely.
No attempt to make any construction.
Absolutely.
The construction, in fact, has been taken on plot number 481.
Absolutely.
Which your client also admitted to have executed a deed. In their
Absolutely.
favor.
Absolutely.
On that score, we say that once they have appeared,
That
they have
means
said that they are not going, there is no imminent threat as this point of time. And then
They also admit the same thing with the court below, but court below is saying, no, there is no, you did not obtain any order from the High Court. You have challenged my order. Kindly see the impugn order now. Without evidence, I can't take anything. I can't decide anything. Internal page 2, order dated. Well, your lordship will find from the memorandum of appeal.
the nature of the interim order, injunction, sorry, nature of the temporary injunction.
Not to change nature and character, not to create any third party
But
interest.
it cannot be done because it's a green land.
Would remain,
That's what I'm telling. But kindly see the order rejected.
but he has not applied for conversion as yet.
No,
That we have stated. Kindly see the order.
There is a threat now.
But still, yes.
There is a
But
threat
kindly, yes, my lord.
because he is saying that he has not taken any steps. He will not go.
Kindly record that, but kindly see the trial court
But
says I can't pass any order of injunction.
Wrong.
But that's I'm
On the academic side, it is wrong. For academic purpose, the trial court has gone wrong. But ultimately, the decision is because they have.
yes, kindly record that submission. I have nothing. If your lordship
but there
record it,
cannot be any construction on that land. Well, there cannot be any construction on that land, my lord, because it's a green area. Its lordships has recorded that on the previous occasion.
আমাদের সেইটাই লোয়ার কোর্ট সেটা যদি না বলে কি করবে স্যার? $471, 481 নিয়ে ওরা যা করতে পারছে। আমি তো 476 এটা কারণ দেখতে পাবো। No, only in respect of 471, but what they are saying now, my client has seen that one JCB machine has come. If Mr. Mukherjee is saying, I have nothing to say.
But that
What is this machine?
JCB machine.
but I have to take instructions. If there is any machine, my lord, then I have to take instructions.
মাটি করে
My lord, my instructions are it's a green land. There can never be any construction on that part of land. Your lordships have recorded that on the previous occasion. And that was our categorical submission before the court below also.
I'm sorry, it is a mark matter in the top, JCB machine in that.
What is this JCB machine? I do not know. What is the purpose of it?
Yes,
But it is beyond the boundary wall.
My boundary wall is within them. Beyond that, that is my land, 471.
481 is this land up to boundary wall.
Yes.
And beyond that, 471.
My lord.
Maybe they kept in for other purpose, but my client is apprehended.
Yes.
কাজ করে এই ছবি দেখি at least.
Is it up to boundary wall which is shown is a 481?
481,
And beyond that is a
471. If they say they will not do anything, but
That is already stated.
This GB.
But I have to take it. I don't know, my lord, about.
JCB machine টা কি ওই মাটি করে যেটা?
But JCB machines are normally used for, my lord, for excavation and all those things, my lord. I don't know. That's normally it's used for excavation and other things. My lords will kindly record my statement, my lord.
Yes, yes.
Yes, and
Record it.
kindly will not interfere.
That the trial court applied a wrong principles of law, rejecting an application for temporary injunction, and did not take into consideration the respective stance of the parties in their pleadings filed before the trial. It is submitted that the respondents have put what is that machine?
JCB. It's In the internet, it says it is using for the purpose of construction and
But
digging.
excavation, I
I put an excavator.
My
I have to take it.
JCB manufactures equipment for agricultural construction.
But JCB is in a
Oh, that's the company name.
company name, man.
No,
That's
no,
a
what is the-
JCB Joseph Trill Bamford.
Well, it's an excavator, man. Brand
It's
name.
an excavator. Put an excavator at it says at the plot number 71. And intend to make a message. All instructions submitted. That is, client has already disclosed his stand in the trial court, and he is been instructed to disclose such a stand in the instant appeal as well. That the plot number 271 is the stand, and therefore this construction to be undertaken there. If it further the respondent has not applied for conversion of the green flag into any other category, and therefore there is apprehension with regard to the alleged changing the nature and character as well as taking a construction.
A transfer, my lord.
However, it is, however, the appellant relies upon the photographs stated to have been taken of the same plot number 1 depicting a machine having put thereupon, in which the learned advocate was the respondent seeks time to take unnecessary instruction from his client. Well, in such view of the matter, we do not find that with regard to the change of the character construction at the plot number. However, we permit the council to take the necessary instruction on the basis of
Kindly
I
dispose
think
of.
this kindly dispose it off, man. Because
Kindly dispose of.
my lord, our stands have been recorded. My lord, kindly disposes it off, my lord. This is no point.
in view of the above,
Keeping pending for our benefit.
in view of the above, we do not find that the ultimate decision of the trial court can be ultimate decision of the trial court taking an application for temporary injunction can be is liable to be interfered with. However, we do not make any comment on the observations recorded in the included. We are conscious that such observations are traumatizing in nature and have no bearing at the time of final hearing of the proceedings.
One observation is required. In view of this undertaking,
In the event this the parties alters their stand, it is open to the parties to apply before the trial court for an appropriate order. And the disposal or rejection of the application shall not stand in the way of deciding the said application based upon the changed circumstance.
Grateful.
on the last occasion, Lordship made one observation, if that be fallen by your Lordship, that in view of undertaking, no order is required to be passed. Otherwise,
What I said.
Uh,
What I said.
Lordship,
appeal and applicant all disposed.
may I permit to make a mention?
Or there are two pieces for appeal and application.
One only. Appellate side, one.
Lordship, may I permit?
Both appeal and applications.
Lordship, may I permit to make a mention, your Lordship? Item number 27, your Lordship. Lordship, it was my fault, your Lordship. It was my fault, your Lordship.
So what
But
can be done?
kindly, it was Lordship directed to after vacation, Lordship. Kindly keep it.
Not this week, we have to.
Yes, your Lordship. Kindly keep it tomorrow, your Lordship.
No,
Kindly.
why not? Why not today?
But Lordship, after.
No, today. We are coming.
Yes, sir.
back
Yes,
to the
Lordship. Lordship.
You are appellant or respondent?
I'm appellant, your Lordship. The second appeal admission for that. Lordship. Grateful, Lordship.
Yes, Paul.
My lord, I'm may I present to your lordship, this matter is second admission of second appeal, your lordship, but there is a delay, your lordship. Application has been filed, your lord. My lord,
Petition, where is the number?
my lord, my lord, delay application also been filed, your lordship. Section 5 application also filed. There is a 132 days delay.
Oh, then one is the registered application has been, the registered application has been filed out of time. Accompanied with an application for convocation of the can follow. Since the said application is required to be heard by the single bench before the matter could be posted for the come on, let this matter go out of this. Liberty to the appellate to pray for a listing of the said application for the single bench.
What is second appeal, your lordship, for admission?
Have you ever read the appellate side?
My lord,
Our rules say that if petition application is taken out in the second application has to be heard by a single bench first. Thereafter, if it condones,
my
then
lord,
it will count.
but I'm tendering my apology.
Show him the provisions of the appellate side.
I'm tendering my apology, your lordship.
My lord, 61 was passed over, my lord.
It was never, it was not. Nobody responded.
Not, I was told that somebody took pass over, my lord.
No. 61 is the Passover, clear. Sir. Nobody. You are here with wrong person.
But I apologize, my lord.
Is there any caveat?
My lord, I do not. Caveat was there at the time of revision of application, but although, my lord, I have served, my lord. I have served, my lord.
The other side, we don't know. Watching it. But this is FMPT. So he has the right.
Yes, my lord.
Call him.
No, fine.
Yes.
My lordship, I am for the appellant and I am appearing on behalf of Advocate Anit Rokit. Due to illness, he is unable to appear today. Kindly list the matter after vacation.
Not this.
Yes, yes.
I'm for the private respondent number 1.
Lord, in this matter, Miss Manali Biswas is appearing on behalf of the appellant. My lord, she could not come to court due to her illness, my lord, after the case.
'73, my lord, I'm appearing. Plaintiff is the appellant before your lordship, my lord, and it's a judgment of reversal. Reversal. The plaintiff filed a suit for recovery of possession against the defendant.
What ground?
My lord, it's not a suit for eviction under Premises Tenancy Act. In fact, an agreement was entered into by and between the plaintiff and the defendant.
there was a contract for sale and purchase, but the contract was not given effect to, and he continued possession, for which, my lord, as he failed to execute the document and pay the consideration money, the suit was brought for recovery of possession against him. In that suit, the pro forma defendant was the owner of the suit property, and my client happened to be the developer, registered developer, power of attorney, and the flat is the subject matter of developer's allotment. The developer died, consequently, his legal heirs were brought on record. The learned trial judge granted a decree for eviction that since the agreement for sale was not given effect to, and the entire consideration.
When the agreement for development took place?
2012, my lord. Salta bolbe, 2012. Agreement for development is of 2007. The present impugned agreement is of 2012. The impugned agreement was in fact that the plaintiff in his allotment, the developer in his allotment will sell in his allotment a flat to this developer who will purchase it at 20 lakhs. Now he didn't purchase, he didn't give the consideration money, never shown any interest to purchase it. Since it was not given effect to,
No, the developer is the dependent.
the developer is the plaintiff.
That last sentence.
The pro forma defendant is the owner.
First thing is, what is the relation between the developer and the person who was he was put in position by the owner?
No, he was put in possession by me, developer, by the developer, because it is the subject property is developer's allotment, falls under developer's allotment. Therefore, this developer entered into an agreement with developer for sale and purchase.
With the developer, what do you understand?
No, possibly. The 2007 agreement is the agreement in between developer and the pro forma defendant, by which he was allowed to develop the property. With respect to 2007, I am not in.
Let me frame in my own understanding. In 2007, the pro forma respondent entered a development agreement with the plaintiff for development of its property. Obviously, on a ratio basis.
Yes, ma'am.
That so much of constructed area will be under the owner's allocation, and so much would be under the developer's allocation.
My lord.
The developer developed the property. In 2012, he entered into a sale with the principal defendant.
Yes, ma'am.
In respect of a flat at a consideration of certain price. Yes. And the price was supposed to be paid within a time. But in part performance of an agreement, he was put into possession. And later on, he defied and did not pay the rest of the consideration. Nor he went forward for execution of
my lord.
So you filed a suit for recovery of possession.
My lord.
I think this is the most.
My lord, yes, my lord.
Of putting the facts.
Yes, my lord. There is nothing to be added. Now, my lord, the trial judge granted a decree for eviction in favor of the plaintiff.
Now, you should amend that eviction always connotes proceeding against the tenant.
Yes, my lord.
Say the granted decree
for recovery of possession of this remised premises. I stand corrected, but it's a recovery against the defendant. There was a further direction that I should refund 6 lakh earnest money, which at that point of time was paid, though there was no cross appeal in the suit itself. Now, my lord, the defendant, after suffering, preferred an appeal. The appellate court has reversed the judgment and decree passed by the learned trial judge on the ground that the suit has not been brought by the pro forma defendant being owner of the property. There is no question of filing a suit.
has put another person into position, then it is that person who can recover the position.
That's my lord.
This is on the basis of a possessory right.
Yes, my lord. Now there is no question of right to sue by the pro forma defendant being the owner of the property because the agreement is with. Therefore,
Where is the finding of the person?
memo आपका बिल अच्छा
Not challenge or file a cross appeal or refund of that.
No, I also filed a cross appeal before the appellate court as there was direction to refund 6 lakh. That was also dismissed.
Have you challenged that?
Yes, my lord, that also I have challenged. বলছি ওটা তো আলাদা অ্যাপিল করে তো ফাইল করে দেব I have not filed another.
Then what will happen? Tell me. If you have not, then tell me.
There should be another. Your lordship, there should be another appeal so far as rejecting a dispute.
What we will advise you to do that?
No,
You are the best person.
no, your lordship is absolutely.
Knows law much better.
No, the appellate court since there should be one another appeal. একটা আরো appeal দিলাম 6 lakh টার জন্য for refund, my lord, that cannot be. No, your lordship is absolutely correct.
Is based upon the same point.
No, it's a composite, but technically, my lord, I should file an appeal to that. My lord, because I have challenged the dismissal of suit.
Again, I am asking. You are challenging the dismissal of suit.
Dismissal of suit. Because the decree for eviction has been set aside.
Dismissal goes, then what will happen? Will it revive the cross objection?
No, it will not remain. It will remain. To the extent of direction of 6 lakh, it will remain.
Finding is based on that. Trial court finding is based on that.
Your lordship may grant me a liberty to file another.
Liberty. That is
Not required, I can file it. I can file it as a matter of right.
what you will do.
My lord, since that will be only an ancillary because this is the not ancillary because it has to be, but
That relief was granted.
yes, your lordship is absolutely. To the extent of 6 lakh, it cannot be touched in this. Your lordship is absolutely correct. But leaving aside that 6 lakh, your lordship can, my lord, that
What leaving aside?
6 lakh, my lord,
But
there.
taking the risk, we can't. We will simply say so. And ultimately, what will happen? We don't know. Because that 6 lakh decree is not an independent in that sense, because it is based upon the findings of the trial. That finding would remain binding on
Yes, my lord.
choice is yours.
Lord, I would pray, my lord, that your lordship can admit it, and I will file an appeal.
That is up to you.
Yes, you kindly come. Your lordship may kindly come to page 6, my lord.
Page?
Page 6 onwards.
The finding I just wanted to know, where is the finding of the trial court? Finding really starts from page 11. Page 10 bottom. Absolutely.
I'm sorry. Your lordship is absolutely. Page 10 bottom and page 11. my lordship.
Your Jyotish Mitra was your father.
My lord, the
Jashish Mitra was your father.
father,
He died.
he died. Thereafter, substitution was effected.
What are the grounds?
Grounds, my lord. हमारा printer पर. My lord, may kindly tell to ground number 7, ground 9, 7, 9, 10.
Then it's not a way, sir. Ground has to be drafted in a very concise and precise manner. You are really making all your submissions into the ground. 7. Then next,
Now, my lord, 9,
again the same thing.
my lord, 12, summarily it has been.
The appeal shall be heard on the whether a suit for recovery of position against the independent respondent can be defeated only on the ground that the developer has the right in respect of a project. When admitted the sale of the flat constructed by the developer, that the subject matter and the recovery for the possessory right there is a question. Next, whether the court of appeal below was justified in reversing the judgment of the judge on the score that the development agreement is not registered on the suit at the behest of the people, thereby ignoring the fact that the position was handed over by the developer to the intending purchaser on the strength of the sale subsequently executed. Whether the court of appeal below was justified in reversing the judgment trial court only on the ground that the appellant has failed to prove that the agreement for sale between him and the principal defendant has not been cancelled nor successfully proved in the section. Yes, expedite orders, lower court record, 1 week after vacation, put in the special messenger call.
But I have also prayed for stay of the impugned judgment.
What? Is it what you are understanding? Your
You know,
suit
let-
for recovery of position is dismissed, stay of the, that means what? The trial court degree would survive.
Let me serve a copy and come back.
Sorry.
Sir. Because the
That-
fixation of occupational charge will arise. my lord,
No.
that
Have you seen my dissenting judgment? Affirmed by a special bench. Maram has to be applied here.
since the trial court has
Sorry,
not.
we can't. Your suit has been dismissed. Till the time the appellate court's decree is set aside, you can't. The law of Akbaram applies if the defendant who has suffered a decree for eviction and wanted to protect the position. Then he has to be put on terms. But your suit has been dismissed. And they will be put on terms.
My lord, it shouldn't be so that I may not be allowed to take the occupational charge, but during pendency, he will deposit.
Give a damages. Should I give you
No.
advise you what you are required to do? You know the law better than anybody.
My lord, I will. Okay. আমরা তুলতে পারবো না, but
Requisites for effecting service of notice of appeal upon respondents. Within 1 week after.
Yes.
Then paperwork within 4 weeks
after the open.
after the. I
70. 75.
Yes, sir.
My lord, I am for the appellant, my lord.
Which side?
74, my lord.
Yes.
Lord, let
Who are
this,
the trial court, sir? Plaintiff or a defendant?
following in both the courts defeated in the case, my lord.
I'm asking you, who are you in the trial court?
Plaintiff or defendant?
Plaintiff, my lord.
Plaintiff. Is a judgment of affirmance. Both the courts have
Yes, my lord.
affirmed. Same view.
Yes, sir.
What is the nature of the suit filed by you?
That I am filed the suit for title and possession, my lord.
Possession. So it is a suit based on title and then recovery of possession or confirmation of possession. What?
My lord, for confirmation of position, my lord.
So you claim that you are in possession.
Yes, my lord.
So why both the courts have disbelieved your case?
My lord, facts of the case is this. My lord, the defendant is claiming his right as patta holder.
Patta holder.
Okay. The appeal court is of the
You are claiming as a riot.
Right.
Yes.
My lord, the appeal court.
The land was vested under the State Acquisition Act.
Yes, my lord.
So then if you lost your right, then the government can issue a patta in favor of anybody. How can you claim your right in respect of?
My lord, I may be permitted to submit my submission. I may be permitted to pass
submit my submission, my lord.
What?
My lord, that patta was.
That's a very simple question, because the moment a government issued a patta in favor of a third party, the government can only issue a patta in respect of a property which is a property of the state. Either the state is the owner by other means or by virtue of an acquisition or the land having vested in him, then the state becomes the owner. Then he can also only issue patta. I'm really asking this question. If that being the position, then you are assailing the patta.
My lord, that is not the position. Position is the defendant suppressed the fact that patta was annulled by the competent authority by.
Oh, initially it was done, but this patta was annulled.
Subsequently, that was annulled by the SDO, the competent authority.
Correct.
And that order was challenged before the land tribunal. Land tribunal also rejected his prayer.
Correct.
And department was directed to record the rights in favor of the appellant myself.
Correct.
And that point was considered.
Against that, any high court approach?
No, my lord, he did not make any further application, my lord. And my lord, learned trial judge is of the view, the appellate court, the only question is to consider the validity of patta. But
no, this can't be, because the patta, according to you, has been
yes, my
cancelled.
lord, that was in the order sheet. But the Honorable learned tribunal holded that only question is to consider whether how far the patta is applicable in this case. But the learned trial judge has observed that patta already cancelled. Then what is the fate of that patta? And my lord, that was also only not cancelled. The appropriate form of law is that unless it is approved by the SDO regarding annulment of patta, SDO annulled the patta.
No, I understand. What you say is correct.
Yes.
But the only thing is that what was the finding that whether the land for which the patta was issued is a vested land or not a vested land? What the SDO held?
SDO held that actually it was held by the office of the BLRO and it was recommended the SDO for affirmation. Malar held that the patta holder cannot get more than 1 acre of land. The defendant in the trial court, he is the owner of 1.13 acre. As such, that patta was cancelled according to the proceedings under BLRO, and then it was recommended to the SDO for affirmation, and that order was challenged before the Honorable Learned Tribunal Court.
Mr. Counsel, I accept. So it was not on the ground, the patta was not annulled on the ground that the land is not a vested land. The patta was annulled on the ground that he was already a riot in respect of a land, ceiling whereof is given in the Land Reforms Act. So anybody who is already enjoying a land up to a ceiling limit, this patta cannot be issued which would exceed that ceiling limit.
And
these
he
were
obtained
on
it-
fact.
He obtained it
Suppression of the fact.
suppression.
Correct. But the fact remains, because it is a suit for declaration.
Yes, sir.
Suppose a patta is annulled. Does it mean that the title to the property goes to you? Because it is a vested land.
My
Government may again issue a patta in favor of a third party
Yes, my lord.
who has no land
Yes.
above the ceiling limit.
Yes, my lord, I may be permitted to submit, my lord. In affidavit, I have submitted and also exhibit that I purchased the land from a riot. So
When?
in the year 2000, my lord.
In
the year 2000, my lord, by
is a post vesting transferee. How far you can, whether your vendor was having a more land, because in the 1940, 53 Act, West Bengal State Acquisition Act, of which year? Tell me. 1953.
1953.
So,
My lord, if my lord
vested into the state. You will be allowed to retain so much of it. Now the excess land is a wastage and does not allow to be it becomes a issue. Somebody who is in country who is there so the party is to issue to those persons who are it was selling he was given to the ceiling. Reverted because it will remain a property of the state. Now they can issue the contract to the third party. So this is what, and he has purchased this property. Means if there is already seen the post-vested transfer. Vested land cannot be transferred. Once it has vested to the state, then any person who is having a right ceases to have such land. Sir, tell us, this is a problem which is troubling.
My lord, I may be permitted to satisfy your lordship that if
No, you are fully permitted, but satisfy.
Yes, my lord. My lord, in the trial court on affidavit I have submitted with exhibit of that document, deed of convenience.
Conveyance of 2000.
Yes, my lord. Deed of convenience that I purchased this land.
No doubt.
Yes, my lord. Yes, my lord. I purchased this land. And my lord, it was recorded if it is a government land and
Khatian
1.
I know you were heading.
Yes,
so
my
was
lord.
it included in Khatian 1?
No, my lord.
It was not included in
No,
Khatian 1.
no, my lord. The land was sold.
Whether your vendor in 1953 exercised the option of retention, is it a retained land or it is not a retained land?
My lord, that transferor suppressed the fact and sold the property to me. And according
What suppressed?
Suppressed that he did not make option that this was handed over to the government or his own position. He did not disclose
So
it.
then what is the law? Suppose
Then
if he does not.
Then what is the law? Party who purchased the land, he will not.
No. Post-transferee. Sir, there is a special bench judgment of our High Court. That what are the rights of the post-vesting transferee? I am a part of it. Justice Aniruddha Bose, as his lordship, the then was of this court, myself and Justice Asa Arora, 3 judges bench decision is there.
My lord,
post-vesting transferees, how far they can, whether they can apply for retention now.
My lord, what I am submitting, my lord, there is for suppressing the fact.
I understand, but we are concerned, sir. You have been defrauded.
Yes, my lord. And
but
that
can you assert your title to the property, which is an outcome of fraud?
My lord,
I'm asking you.
My lord, yes, there is the provisions of law under section 14U.
14U.
U.
What?
Where it leads
Yes.
that
Not
if,
here, Land Reforms Act. Huh.
if in such situation, the somebody will not fought, but the land will be deducted from the riot by the government, and my right will be saved by the government. As I am a
Correct.
Jnana
So,
citizen,
correct.
I should not suffer.
So what the government will do? The government
Under the
will
proceedings-
issue a further patta in your favor.
My lord, my lord, kindly accommodate me, my lord. Under section 14U, when I made an application.
Yes, let us see the 14U provision. Let us see. First, let us understand. Land Reforms Act. Where is that? Land Reforms Act এখানে কি আছে? ও এটা আছে। সাহেবকে দিও। Yes. 14 user. ST U. ये देखिए। Sir, this is a restriction on transfer of land by a riot. 14U says that except where he is permitted, again, in a writing by the revenue officer, so to do, a riot owning land in excess of the ceiling area applicable to him under section 14M shall not, after the publication in the official gazette of the West Bengal Land Reforms Amendment Act 1971, transfer, by sale, gift, or otherwise, or make any partition of any land owned by him or any part thereof until the excess land which is to waste in the state under section 14 has been determined and take possession of by or on behalf of the state. So this is a catchword which it says that he has to surrender the excess land beyond the ceiling limit under 14M, and thereafter he can sell. He will not sell. The reason is very obvious that under this act, which is an Agrarian Reforms Act, the ceiling limit is provided that a person can hold how much of land. If he is holding more than the ceiling limit, then what he can do is, circumventing this law, he can sell the excess land to a third party and to bring it within the ceiling limit. So he enjoyed both. A bird in a hand and a bird in a bush, both he is enjoying. This is what is not permitted.
My lord, the government should give me protection from defrauding myself.
You can claim against your vendor who has defrauded you. You can
Already
claim.
I have claimed, and the proceedings is going on, my lord. Proceedings is going on in the office of the BLRO, my lord.
Really?
And my lord, the deed was registered. My lord, deed was registered at the registry office, my lord. There cannot be this khotiyan, my lord. If it is government land, then there will be khotiyan number 1. I have purchased by registered, imposing, paying all the taxes to the government. It is also in evidence.
U3. Sir, you want a dismissal before or after the vacation?
Once I shall do my lord after vacation, but once I show them my deed, my lord, that is registered deed, accepted by the government, and Kotian is there, and he is also taken into oath as evidence from the registry office that this was registered. How the register of office, the government land is accepted to sell in after taking the revenues, and there is the Kotian number is another, and if it is government land, then that will be under Kotian number 1. But there is the Kotian number is another person, my lord, and then, my lord, I shall come after vacation. My lord, I don't know the law, my lord. I want to know from your lordship that law, the position, my lord. But in my position, my lord, I should know the government land should not be in that Kotian number 235 or somebody else. And it
Sir,
will be
the
registered by the
difficulty,
government.
I tell you, when you say so, the difficulty is because under the State Acquisition Act 1953, it talks about the automatic vesting of the land. It never says that any order of the government is required identifying or specifying a particular plot to have vested in the state. It's a more wider act which says that on that day all the land that would vest to the government. Then there is a provision, section 55A, which says that a right is given to the persons to apply to retain the land. If the power, the retention is exercised, then in that event the government will definitely pass an order that you are entitled to retain the land up to a certain limits under the state acquisition. Choice was given to the intermediaries that you can, and thereafter the order of retention is passed, then the person would retain that particular property as a riot. Now the question is, sometimes it so happened that every land has not been recorded under Khatiyan 1. That is why there are series of judgments of this court where you will find a post-vesting transferee. What are the rights which are there? Suppose it is not included in Khatiyan number 1, but it appears that under the State Acquisition Act, his right as an intermediary has vested. Then in that event, the court has decided many aspects in this regard. This is what I really wanted to put you on that. Secondly, registration of a deed in the registering office does not say that the nature of the property goes. If the property is subsequently found to have been vested with the state, even if the registration has been done, because the registry authority will not go and make a roving inquiry like a ED nowadays, like a CBI or the CID or an investigating agency to find out what is there. They will simply go by this, the statement which is made in the deed, and for the purpose of revenue, because the stamp duty is to be paid, that goes to the government exchequer. For the purpose of revenue, they are concerned that whether you have correctly put the stamp duty or not. That is a fiscal statute in that sense, stamp duty act. So they are concerned. You cannot say that since they have registered your deed, so it will not be treated that the government, the land is vested with the government. No. That is not the correct proposition of law.
That is not my only submission after purchasing.
No. I am saying again, suppose
I understand your lordship.
land which has already been vested to the state. Today, take a situation, a government property. Somebody says, I am the owner and sold it to you. The registering authority accepted. And it appears that he has sold the governor house or a land of a governor house. Will the purchaser come and say, look, the registering authority has accepted the deed? They have. So they must know that it is not a governor's house, a part of the governor house. I have got acquired a right. Is it a correct stand? You have been defrauded. If some fraud has been committed on you, you have a remedy against the person who has committed fraud on you. But can you claim a title? I am asking you this. Please consider what is playing in the mind of our bench. Can you claim a title on the basis of a fraudulent deed? Let me put this word. It's a fraud which is committed on you. Can you claim a title on the basis of a fraudulent deed? You can claim definitely a compensation against the person who have committed fraud against you. That's why you have sold a wasted land to me.
My lord, kindly consider.
Dismiss after?
Vacation, my lord.
After vacation, dismiss?
No, no, no.
Or either now or after. It will be dismissed.
My lord, another 2 points are there, my lord.
What 2 points? Now, then we are dismissing before vacation. 2 points, tell me.
My lord, I shall come after that.
Huh?
I shall come after vacation.
Please consider this aspect and then come. If you can say that the 53 Act does not apply, no difficulty. No difficulty. You have to overcome that wasting part.
Tell me, my lord, there are series of orders were passed by the
SDO, by the BLLRO,
and
the appellate authority tribunal. I asked you on what ground the patta was annulled. You told me that this is the ground the patta was annulled. It has nothing to do so far as a wasting part is concerned. None of the authorities has said that it is a wasted land and the patta cannot be granted. Had it been a case, I say that you have the best case on the earth. If those authorities have already held that it is not a wasted land and therefore wrongly the patta was granted to the defendant, we will accept your contention. On that score, we will admit it. But you said that he was already enjoying the excess land and which was later on discovered, and on that ground the patta was annulled. That means that he was disentitled to have a patta in his favor. It is not that the land has not been vested.
No, since I have purchased and since then I am in possession and I am enjoying the land, my lord. And I am paying the taxes to the government and also in the record of rights. And
yes, Vicky.
Yeah, my lord, after vacation I shall come. I am giving you one chance, my lord.
After vacation. Please read the judgment of the special bench of this court. Please read. Read the judgment of the special.
For that purpose, just for your lordship's knowledge, my lord, for that purpose, my lord, I made an application.
My
lord, I am not saying so, my lord.
No, we are taking up your matter.
My lord, I have to give 3 sets of copies with all documents. That is
not necessary. One set will do. Don't worry. But
I'll come after
read that special bench judgment and then come. Yes.
I have contacted
Tomorrow, 16.
I'm grateful. So grateful.
Yes.
The London advocate for the appellant, Mr. Jyoti Prakash Shetty, is unable to attend the court due to his father-in-law's demise, Your Lordship. Kindly, it can be fixed after vacation.
Not
Grateful,
this,
Your Lordship.
not this week.
Grateful.
My lord, for the appellant, I am led by Mr. S.K. Zubair Ahmed. He is the conducting advocate, and we sought for the instruction from the client, my lord, and we did not even get it right now. So kindly can it be taken up?
The
on the-
appellant
Yes, my lord.
did not get any instruction,
No, my lord.
even while filing the appeal.
Yes, my lord. It's in
You did
very
not get
initial
any instruction even while filing the appeal.
to proceed, my lord.
You wanted more lucrative instructions before the vacation.
My lord, this is the instruction which I get from my senior, next to my senior. That's
Ask him
why.
whether he is expecting a lucrative instruction or what. One is lucrative to him for the vacation. Come after vacation.
Okay, man. Much obliged.
Convey this message to him. একটু হিয়ারিংটাই ফিক্স করতে হবে ছুটির আগে।
My lord, 82, I am led by Mr. John Kumar Dash. I am appearing for the petitioner, my lord. Kindly take the matter after vacation, my lord. '86. My lord, Sanjay Sarkar is appearing for the appellant. He is due to illness not come to the court. There have some difficulties position. Kindly direct this defective position in this matter.
Yes. What is the defect?
I don't know.
So, what do you want, madam? Tell us.
Fixed any date.
Today,
No. Day after tomorrow.
then after vacation. Next.
My lord, for not today, item number 85.
Why not today?
Not this week, sir.
Not this week.
Yes. My lord.
This week.
I am for the appellant, my lord.
Yes.
Item number 90.
Item number 90, my lord.
Please come.
My lord, some defects are
90 does not have a defect. At least the cost list does not show that.
then, my lord.
Yes. Who are you in the trial court?
I am the defendant, tenant.
Defendant, tenant.
Yes. And
Judgment of affirmance.
Yes, ma'am. Against. Then both the court.
Suit for eviction on what ground?
On reasonable
requirement.
And another is the defaulter.
Default.
And
So
my
both
lord,
the courts have found that the plaintiff requires the suit premises.
yes, both the court found, but there is no material or evidence on the part of the plaintiff to prove his reasonable requirement. The court,
There is no
there-
material. What material you expect that he
one
should
of the
bring?
court only on the basis of the commissioner's report. The ground number 4, my lord, I have, and there is no default.
Who is the advocate and record, sir? Put your signature here. We will direct you to put your signature.
I will give you.
Yes.
Liberty maybe.
So they have not proved.
One
How
ground
they
is-
have to prove it, sir?
Yes, my lord. There is a, my lord, if your lordship kindly see another ground, there is a ground of default, but I have the certificate copy, which says that the 7(3) application filed by the plaintiff was ultimately rejected. That is not reflected in the order. So there is no ground of default at least. These are the two
But
grounds.
the decree for eviction can be passed on any one or more grounds.
More ground.
So reasonable requirement is one ground.
One ground. That I have.
Plus, suppose default goes.
Yes.
Wrongly passed.
And
What
another-
about reasonable requirement?
Or they have only relied upon the defendant's evidence, defendant's witness,
What?
the position of the in the witness box.
What?
That the defendant did not inquire about the plaintiff substitute accommodation. Why defendant did not inquire about the plaintiff's substitute alternative accommodation. Alternative accommodation, whether there is any or not.
He has said that he has no reasonable suitable accommodation.
And
what more a plaintiff is supposed to
plaintiff
give an
is supposed to,
evidence?
my lord, do is they have said
Except saying I have no other accommodation.
And another thing is that, my lord, the number of persons living with the plaintiff in already in occupation of 3 rooms.
3 rooms.
And 1 room
How
is,
many family members of the plaintiff?
according to plaintiff, 11,
11.
but no name particular
Oh.
and any other thing is disclosed.
It's not
And
disclosed.
it is also on the materials on record that 1 room is lying as a damaged condition, and I am only a tenant of 1 room, having a lot of family members. My submission is that if at all there is a reasonable requirement,
that will not be satisfied.
That damaged vacant room can be utilized by the plaintiff. That has not been considered.
How you
That is lying vacant. It is on the order.
damaged condition you have said.
Yes,
Then
according
how
to
you
the
will-
order.
How you will utilize it?
The plaintiff may repair it and
Who will
suitably
bear,
use
who will
it.
bear the expenditures of that repair?
Well, if
Because the
the-
plaintiff may not have a money. Who
Well,
will-
that is the subject matter of the materials on record, my lord.
Yes.
That is subject matter. That is not explained.
That's
That
a
point-
very important question.
Yes, ma'am. That is not explained. But there is a,
Because I know one judgment of our High Court in this regard
my lord.
against this notion.
Yes, my lord. Yes.
So that's
So-
why I'm asking this question.
Yes, ma'am.
There also the learned, the honorable judges has put this question that who will bear the cost?
Yes. But that will be arguable point if you lordship can-
Arguable, settled proposition of law. Our High Court has settled this point.
I'll try to convince on that point, my lord, that whether
We are,
at
we
all.
are asking you to convince.
So now, my lord, at this stage, my lord, I cannot.
This
with
is the admission stage. Will you not show that
So
what
that
is
is
the
the point.
substantial question of law?
That is the substantial question of
That's
law.
all.
These are the 2 main points. And default and the reasonable requirement is not sufficiently proved by the plaintiff himself. These are the-
Anything more?
These are the 2 grounds.
That's we are coming back and dictating.
Grateful. My lord, only, my lord, I am paying indulgence of your lordship, my lord. Only I will read two lines before dictating the order. Page number, my lord, 36 and 36.
30?
Page number 30, running page 36. It is a trial court judgment. In the top of the middle,
Internal page, can you say?
internal page, my lord.
At the bottom right hand side, you will find
Yes, my lord. The internal page is 17
17.
of the trial court.
Yes.
And kindly read the few lines from the top. I am reading from the middle.
Consists of 11 members.
Yes, my lord, the advocate commissioner,
No, no.
my lord,
The plaintiff's family consists of 11 members.
this page.
Plaintiffs themselves means husband and wife,
Yes,
4 unmarried adult sons,
yes.
3 unmarried daughters,
I am reading, I am reading.
and 1 married
Yes, my lord.
but deserted daughter.
Not
1
kindly-
granddaughter of the plaintiffs and 1 married daughter who often come to visit the suit premises along with the husband and child.
No, these are not true facts. This is a story.
Hmm?
They could not repose to that effect. That how many members actually they have. No name.
Now, if I have 4 sons, will I bring all my sons to
Have
prove?
to take the names or something.
Which
that
one?
These are my sons. But my main point was
Have
that
you said that he has no son? He has only 2 sons by this name in your opposition?
not, well, that is one point. But what I like to, my lord, point out before you last, my lord, two lines, my lord, leaving two lines from the top. I am reading just, my lord. The advocate commissioner stated that middle. I am reading. Advocate commissioner stated that the suit holding has 6 rooms. The plenty were in occupation of the 3 rooms.
Correct.
Out of 3 rooms, 1 room is dilapidated condition.
So he is actually in possession of 2 rooms.
He is 2 rooms. So 1 room is dilapidated. He is not using that room. One of the advocate commissioner further stated that 3 rooms are occupied by the tenant.
So
Another
obvious.
3 rooms is occupied by the. Now, out of said 3 room, 1 room is roadside facing is in the occupation of the dependent tenant. Now, the report of the commissioner is like that. My actual submission is that I am a tenant from the erstwhile landlord, my lord. 1 room, tile-setted room. I am also having lot of family members. Instead of reasonably, it is not a bona fide requirement as per my actual submission. That room can be easily, suitably repaired, even at my cost. It is a tile-setted room, so that I may not be evicted. This point has not been considered by the my lord.
If there are 3 rooms, let us proceed that you will pay the costs. Whether all these family members can be accommodated there.
Yes, my lord. Because
3 rooms.
My lord, because to that
4 unmarried adult sons.
Yes.
So in a foreseeable future, they are likely to be married and they will share the bedroom together.
Yes, my lord, that is a difficult situation, I know. But at the same time, my lord, if I balance between these two, so for the biddings is concerned, this point is oversighted by both the. Only to that effect, my lord, if the trial is conducted or by remand, my lord, that point may be covered.
What?
For that purpose, that whether this tile-setted room, they are requiring 1, but they are not using 1 room under their occupation. They can use. It is not their case that they are really lacking of the sufficient number of rooms. They are saying that 1 room is required.
But both the courts have proceeded that the plaintiffs have 3 rooms, out of which 1 is dilapidated. But the court has not. Court has considered 3 rooms.
3 rooms.
Now,
But 3 rooms.
now whether 3 rooms are sufficient enough.
No, court has not considered.
Let us see. Dilapidated room also is a sufficient accommodation. Whether those rooms are sufficient enough to cater the need of the landlord. That is what is the first question. What do you feel that a husband and wife having 4 unmarried adult sons, 3 unmarried daughters, 1 married but deserted daughter, 1 granddaughter of the plaintiffs, 1 married daughter.
I can appreciate that point.
How much room a person require in his house? After all, it is his house.
Also, a lot of members.
Now, you are talking about if there is one concept. What you are talking about is undue hardship concept.
Yeah, undue.
But the
point.
Legislature in the West Bengal has not incorporated that concept of undue hardship. It is there in some other state's legislation, but in West Bengal it has not been incorporated. Can we borrow those legislations to operate in West Bengal? Can we?
But it is my lord, point of law, my lord, at this very
Point of law,
very face of this.
that is a very, very pertinent. Can we borrow? A state has a legislation, another state has another legislation. We borrow the legislation of another state and apply here.
Only consideration may be given, my lord, if our statute is silent on that point, then if this, our statute is silent on that point, that statute can be considered.
That can be taken.
That if our statute is silent at all, then
extraterritorial operation, whether it is permissible under the constitution.
That is one
It
point.
is, then under what circumstances?
That is one point, my lord. Another point is that what both the court below has considered that this is the 2 rooms under the occupation. They are not considered 3 rooms.
Let us proceed 3 rooms. We are saying 3 rooms. Let us proceed. This is the structure of the family. Now tell us 3 rooms are sufficient.
Well, 11 members per room. If I say the son will, present position we do not know. What is the now present? Because it is not a static concept. Your lordship knows better than me. That reasonable requirement. There, but the dependent family also, my lord, will face the tremendous hardship, my lord. So considering
that
that 3 members per room, 4 members, less than 4 members per room, in our position only 1, and they are a child-centered structure. So, my lord, balance if I say that if I consider myself in a position of the tenant, that the landlord has to, my lord, prove their case of bona fide requirement. My full submission is that they pleaded that they are only having 2 rooms. Both the court went by that direction. Did not consider 1 room. My lord, it is not bona fide requirement, my lord. And never, my lord, only consideration to be given for the limited purpose, my lord. If this point is, my lord, considered, my lord, then only, my lord, there is a substantial question of law.
Correct.
This is my submission, my lord. And default ground is already covered. There is the order from the certificate copy. Default is made. Their application under 7C has been rejected because all the areas have been paid, which is also not reflecting from the order, my lord.
Forget about it.
So default I am
so reasonable requirement, we are more concentrating on the reasonable requirement.
And kindly your lordship may look into the second page also, page number 37, that the admitted on doc for how the case has been proved. I am saying, my lord, and the rest 3 rooms are in the occupation. The last paragraph of the page number 36. I am reading from there.
Now, can you come? What you are arguing is very, very, very innovative and very enlightening. Can you come to page 18 of the trial court judgment? You say that they have not proved the composition of the family. Can you come? The first very line.
Admitted on doc.
Yes.
Admitted on doc that.
Who admitted? DW1 means your client.
Yes.
Correct.
Yes. Doc.
That Devanando, now name comes. One of the son, the name comes, Devanando Kaha. You said that they did not disclose the description name.
Yeah.
Now, if he says Devanando Kaha, the son of plaintiff and his family members are residing in 2 rooms in the suit premises.
Yes.
This is an admission by you. Then the defendant in his evidence, DW1 also admitted that PW1, Devanand Kahar is married and his 3 unmarried brothers. So you also admitted that there are 3 unmarried brothers, means 4 sons, are also residing in a suit premises.
Then, my lord, next line, my lord.
So 4 sons are admitted by you.
And these 3.
No, you have no denial. Then, on perusal of evidence of it is found that the plaintiffs along his members are residing in 2 rooms in the suit holding with the inconvenience.
Yes.
There is no dispute on the question that plaintiffs are the absolute owners.
Yes.
It is rather admitted by DW3, that the plaintiffs along with his family members are residing in the same house.
Yes.
So there is no other house available to him. The defendant has failed to substantiate the plea by cogent evidence.
Yes.
Now, if we go by 4 sons, which is admitted, how many rooms a person required to cater himself and his 4 sons, out of which admittedly one is married. So at least he is also married. So the plaintiff and his wife requires a separate bedroom. He can't share his bedroom with anybody. His first son, who is also married, requires a separate bedroom. He can't share his bedroom with anybody. Now remaining 3 sons. They are likely to be married in future. So everybody, three sons requires a separate bedroom for themselves also. So it goes to 5. Then at least one kitchen. How you will cook a food? Inside the bedroom, one is not expected to cook his food. Then at least he requires one room for his dining and drawing drawing room and a dining room combined. Let us go, not separate, combined. One room for that purpose. One room at least he requires because other family members, relatives sometimes comes and live here for a short stay. They cannot be accommodated in the bedroom. They have to be provided one room. So if we go by the simple mathematics,
that is true.
So he requires at least 8 rooms. And he is in possession of only 3 rooms. Let us go by that, 3 rooms. 5 rooms he requires. So your room is coming within that 5.
My case is that the very root of the case is that these plaintiff purchased from the earlier landlord. It is the case. Second point is that when he has purchased, he used to know that what is my requirement and what is my status, what is the status of the tenant. I have categorically, it also appear from the order, that is the tile-shaded room. I cannot afford that luxury to the tenant also, not to me. That everybody per member there will be a room, or you better to stay as a mess. There are so many people living in a mess. Now he is also staying in a mess, knowing fully well purchase the property. There are other tenants also. Not because they're targeting me, the problem will be solved. There is no other case filed by against the.
So you are, no, let me understand the point. So you wanted to say that even if you are evicted, you are there in a one tile shelled room, their requirement would not be satisfied. They will be still short of many rooms.
No, my lord, I am just submitting, my lord, opposite to that. I am submitting. Their requirement is not what my lord rule I submit. Perhaps it's not like that 6 rooms or 7 rooms. 11 members, if I suppose that all are staying in the room, same premises. They have, from the very inception of the tenancy, they are staying over there. No newborn child has been there. So knowing fully well purchase the.
Can you expect a newborn child in such a situation?
No. I'm talking about their future also, comparing with the, now they have filed a suit that I have 2 rooms, I have 1 dilapidated rooms, and if that is equated, so for the bona fide requirement, it depends upon person to person. Living standard of the tenant, I am not talking about his standard, I do not know. Of the tenants is the under property line. They tile shed room, if you see the
the law of the state is that if a person who is living below the poverty line, then this law will not apply.
No.
He should be absolutely immune from any kind of a law to apply.
One is requirement with little bit comfort, and one is requirement under luxury. So here no question of luxury.
So according to you, one is a requirement of comfort, and another is a requirement of compulsion.
Yes, both of us are requirement of comfort.
Yes.
Both the plaintiff and.
So this is a requirement of comfort. Yes. And all person must live in one roof. They will be more integrated in the family, more attached to the family. And that will be a very healthy thing in this. No, it's a good notion. You are really saying that if 11 person lives in one room, it will create a more bonding amongst themselves. They will be more united, closely knitted. then if they live in a separate rooms,
No, no.
not good
My
for
lord,
the
our
society.
situation is like that. Lot of members in a single room. They are at least having 3 rooms. I have more than 11 family members. More than.
In one room.
One room. In a dilapidated style-set structure, they never carried on any repair work. Even in during monsoon, is all the ground. What is
Why you are
going on-
living there in such a dilapidated house?
Alternative
Every
backward-
time during the rainy season, you cannot sleep in the night, nor sleep in the afternoon or in the morning. Such a life you are living there. You should also live with comfort.
My lord,
Live it. This property, go somewhere good, having a good infrastructure, ambience, facilities, amenities. Enjoy that. Why you will be compelled to live in this situation? This is absolutely not conducive for you.
My lord, only question was I tried to point out one of the requirement is not, my lord, very much proved. My lord, they have to prove their requirement. My lord, they have proved from my face. They have proved their case, putting the dependent on the dock. They could not themselves prove the case. They could not prove the case. This is the case on the presumption the decree has been passed. Presumption on the basis of the commissioner's report. There is what I, the learned judge.
What do you mean by presumption?
Learned judge.
I do not know about presumption.
Both the learned judge has held that this suit property is required for bona fide requirement of the landlord because they have presumed the report of the commissioner as correct, but the commissioner report even said that the same thing, 2 rooms under the plenty possession. My simple submission is that if the one room is,
your submission must be on that basis.
That is my point, only point.
Can you say anything on this? Come to page 17. The first paragraph, last sentence. Neither the plaintiffs nor the defendant filed any objection to the said report of the advocate commissioner. And the said report was marked as exhibit 10 collected.
Yes.
You do not oppose, object.
Yes.
Then still the court will not look into the.
But this is not conclusive. True.
Yes.
But law notion, your lordship knows that it is a settled law. The landlord is the best judge about their requirement. They said that I am having 2 rooms. I require your room. This is their case. They did not say that because commissioner report, even if challenged or not, that may be a help otherwise to come to a conclusion by the court below. But my lord, responsible submission is that their case is very clear that they require 1 room belonging to me because they are only in a condition, habitable condition of 2 rooms. They are under their occupation. So if that be the case, commissioner has filed his report like that. So what about the 3rd room? It is totally absent. My question is that I know there may be hardship, but if I consider all the aspects, what is apparently on the face of it, it appears that both the plaintiff and defendant are knowing fully well the tenancy was continuing. Now suddenly filed a suit on the ground of bona fide requirement. Suppose, kindly visualize if a person knows that his property is full of encumbrances by the other tenants and the plaintiff is not in a very comfortable situation, he purchased that property. It is not a case that the family members has grown up and adult members or their sons and daughters are getting married because of that family members. This is not their case. Case, the number is same, static. Static.
Not case.
Static.
So expect.
So they have to.
Case he should. What case a landlord is expected to make out?
Or a landlord should.
Should I take it from your argument? Because whenever I say I take it this, you say no, but you repeat the same thing. That's why again I am saying.
No, I am not repeating. I leave you.
Again, what I gather is that the person purchased the property knowing fully well that there is already a tenant, and also knowing fully well that I will only get 2 rooms or 3 rooms in the property.
then according to you, whether such a landlord is entitled to file a suit for recovery of possession or eviction on the ground of requirement. What is your reaction? This is what we really wanted to say. What is, according to you, is the law? That such a landlord, the purchaser, cannot evict any tenant inducted by his vendor on the ground of reasonable requirement. Is it what we wanted to say?
Not exactly that.
I knew it, that's why I
That
said.
is one aspect impliedly said, but main point is that one room has not been considered. In the trial, entire trial and the appeal court, so what about that dilapidated room? If they renovate that room, requirement is fulfilled.
The appellate court can definitely take into consideration. Yes, take into consideration.
But then I have to give a chance that man or two.
What
Chance, because it is not matter on record.
Suppose if we take it that it is another room, that we can, because it has come in the evidence that one room is in a dilapidated condition. According to you, both the courts have proceeded on the basis that there are only 2 rooms available.
Yes.
Third room has not been considered at all.
It is. It's on record.
Suppose appellate court can do it. It's a continuation of the list. We take it, 3 rooms. Whether the facts or the evidence which is adduced by the parties even justify that even if it is a 3-room, something more is required. We can, as an appellate court.
Then my lord, this will submission.
Why
My lord, forum loss will be there.
Yes.
If this point is taken care of, could have been taken care of. Then the decree could have been dismissed. Suit could have been dismissed.
You know the law that
the first forum I have lost.
Conclusion is found by the appellate court to be correct. There is no difficulty on the part of the appellate court to substitute his finding in his own way, if the ultimate decision is found to be correct.
But based on the same same material on record,
Oh, absolutely.
If I see, suppose my lord, I'm just last part of my submission. If I say there is a lacuna in the decision making process, if there is a lacuna in the decision making process, then the appellate court, my lord, will fulfill the lacunas. My full submission. Otherwise, my lord, but this point may be considered, my lord.
For enlightening us on this point.
My lord, my full submission is that let it be
The
remanded
law-
back.
The law which is more or less settled to a catena of the judgments and or decisions is sought to be unsettled with the eloquence of the counsel for the appellant. The landlord reasonably requires the suit premises for his for him as well as the other family members, and approach the court to pass a decree under section 6 of the West Bengal Premises Tenancy Act 1997. The landlord, state respondent, categorically averred that his family consists of 11 members, out of which 4 sons are unmarried, 4 sons, 3 daughters are unmarried, and there is 1 married daughter who was unfortunately deserted by her husband subsequently and is also residing with him. It is further stated that another married daughter often visits and stays with him, and therefore the accommodation available to him is not reasonable, suitable. to cater such needs. The defendant's appellant did not deny the composition of the family. Rather, the first witness of the defendant appellant admits that one of the son is married and residing at the suit premises. And further admitted that the entire family of the plaintiff's respondents are residing in the suit premises. Both the courts held that the requirement of the plaintiff respondent is reasonable, as he is not in possession of reasonable suitable accommodation elsewhere, and proceeded to decree the suit. A point is sought to be raised before us that out of 3 rooms, 1 room was alleged to be in a dilapidated position, which has not been considered by the court as a reasonable accommodation, when the same can be made habitable by making a repairs by the plaintiff respondent. It is strenuously argued that both the courts have proceeded on the basis that the plaintiff respondent is in possession of 2 rooms, thereby ignored the 3rd room, for which the matter should have been remitted to the trial court to reconsider the issue on remand. It is further submitted that the plaintiff being a subsequent purchaser, was well aware that that 3 rooms in the suit premises are occupied by the tenant, and being conscious of such reality, having purchased the same, it creates a brindle on him to claim the eviction of a tenant on the ground of residence. It is vociferously argued by the counsel for the appellant that the defendant appellant is occupying 1 tile-shaped room and living with 11 members, and therefore there is no fetter on the part of the plaintiff respondent to accommodate themselves with the existing accommodations, and eviction would cause undue hardship on the tenant. Lastly, it is noted that the commissioner's report is not sacrosanct, and therefore both the courts have proceeded on presumption in upholding the claim of the plaintiff respondent. Though feebly it is submitted further that the trial court as well as the appellate court overlooked the fact that the entire rent was deposited under Section 7 of the said Act, and therefore, and the application under Section 7(3) of the Act was dismissed by the trial court, thereby refusing to strike out the defense for non-compliance of the requirements under subsection 1 and subsection 2 of Section 7 thereof. We are unable to countenance, we are unable to comprehend the proposition of law sought to be raised before us on the above score, more particularly when the matter is judged on the basis of the parameters of law as well as the pleadings of the respective parties. The parties were put on trial and the witnesses were examined in support of their respective stands taken in the said proceeding. We are not unmindful of the proposition of somewhat settled proposition of law that in order to succeed on the ground of reasonable requirement, the court must venture to see whether such requirement is genuine and a bare necessity of a human being. The court shall refuse to pass a decree on the ground of reasonable requirement if it is found fanciful or a mere wish and desire of the landlord to evict the tenant from the tenant. The extent of requirement varies from a man to man, depending upon their status, economic, their status and the position in the society. And therefore, there cannot be a straight jacket formula in this regard. There is no denial on the part of the defendant appellate on the composition of the family members, on the composition of the family of the plaintiff respondent, and there is no dissent that 3 rooms are available at the suit premises with the plaintiff respondent, out of which 1 is in dilapidated condition. The appointment of advocate commissioner to make an inspection in such scenario is inevitable, as the court is required to see the extent of the possession of the respective parties and the nature of such possession and the manner in which the same is being used. It has further impact on the accommodation, they have impact upon the reasonability and the suitability of the accommodation. available to the plaintiff respondent, which is one of the ground, which is one of the ingredients of section 6. Section 6 within bracket 1 within bracket small d of the said act. In order to succeed on the ground of reasonable requirement, the landlord has to prove that he is not in possession of any suitable accommodation within the municipal corporation or the municipality within 10 kilometers from the suit premises, and that he reasonably requires the premises for his own occupation and for the occupation of his family. The subsection 1 of section 6 does not contemplate that the decree for eviction cannot be passed on one ground. Rather, it is manifest therefrom that the eviction can be sought on one or more of the grounds enumerated therein. And therefore, if the landlord has been able to prove that he reasonably requires the suit premises for his occupation and for the occupation of his family member, it would invite a decree for eviction to be passed against the tenant. The question of unjust undue hardship as raised by the counsel for the appellant is not tenable, as the legislature have not incorporated such concept within the ambit of the said act. The eviction is not decided on equitable principles, where the court is required to balance the rights of each of the litigants in order to render the justice. We are conscious that the Rent Restitution Act was introduced to protect the tenants from the hands of an unscrupulous landlord is in seeking the eviction at his wish. But equally, the landlords have also been permitted to seek eviction on the grounds enumerated therein, which is the primary reason for incorporating subsection 1 of section 6 of the said act. Admittedly, the the composition of the plaintiff's family is large. And even if we accept the stand of the defendant appellant, that one room which is termed as a dilapidated room can be suitably used for catering the needs. Yet the bare necessity of living cannot be ignored, and such room and 3 rooms available to the plaintiff respondent is too scanty to stop. An interesting point was raised that a purchaser of a tenanted house cannot seek eviction on the ground of reasonable requirement, having aware of the fact that such premises is fully tenanted or partly tenanted. We do not see any embargo in the statute. Rather, the converse inference can be drawn from subsection 2 of section 6 of the said Act, where a moratorium period of 1 year is incorporated. Deluding the subsequent purchaser to file a suit for recovery of possession on the ground of requirement for building and building, addition or alteration, or for own use and occupation. Such embargo of 1 year may create a brindle on the part of the landlord in seeking eviction on such grounds, but does not create an absolute fetter on the part of the landlord to institute a suit for recovery of possession after the expiry of the said moratorium period on the grounds as mentioned therein. It thus goes against the true purpose and spirit of the provisions of the statute, and therefore the contention of the counsel for the appellant being contrary to law is not accepted. The law does not stand in the way of the landlord in seeking eviction against the tenant, even if such tenant is evicted, yet the need remains wanting. The tenant cannot dictate the landlord to squeeze within a small area or the accommodations so available. And therefore, the concept of unjust hardship have no role to play in the present act. From whatever angle we look at it, we do not find that the incident
appeal involves a substantial question of law. The same, the appeal is hereby dismissed. No order has to come.
Faithfully. The only thing leave is to put his signature on the certificate of the.
We have discussed it, what more?
আমি ওটার পরিষ্কার কপি এনে দিয়েছি।
What has happened?
SLP is dismissed. SLP dismissed.
Dismissed.
But this is the order.
Lord, I'm just handing over to you.
We don't know. We have been suddenly given. We have been given.
I'll tell you, Lordship.
Understand there are two appeals, one by a Registrar General Appellate side of the
No.
High Court.
But one by the High Court, the other is by the candidates, Lord, who are unsuccessful in the selection process.
Yes.
Lord, there was a
The hearing stage.
hearing stage. The appeal can be
Only
heard.
one thing, Your Lordship, my Lord, sorry, my Lord, I'm interrupting Mr. Kaur, my Lord. I have brought two copies for my.
ये दीजिए. Lord, it concerns, Lord, promotion to the post of Deputy Registrar Legal from the post of.
Can it come after the?
Yes, yes, of course.
Yes. And in the meantime, my Lord, permit me, my Lord, to implead the promotee as a necessary party. This was also, yes. Yeah, I know that. I will not be, my Lord, making that submission.
The prayer of
And
the
then-
respective council. Then you can fix the matter. We are
But,
looking on second.
Yes, Lord.
Second. Ninth.
Yes, of course. Tuesday.
Lord, may I say one thing? Lord, I have a matter over there. Can you, my Lord, excuse me?
On ninth.
Ninth. My Lord, any date, I do not, I say.
Choose Corona, bhai.
I have nothing.
Problem
No.
Tell us. Which, any day, 8, 9, 10, 11, 12.
11, 10.
11 is a Thursday.
11, 10.
11 is a Thursday.
Yes, I have nothing.
Thursday, there is no problem. Lord, the filing of Lord formal paper books may be Lord dispensed with. Informal paper books may be dispensed with because we have annexed.
All documents are on record. But only one document is not on record, which has been placed before the division bench of the Honorable Chief Justice. Those are the two, my Lord, copies of the tabulation sheets of the marks given to the particular persons. Now, my Lord, what I did as an abundant caution, I have affirmed a supplementary affidavit. But I will, yes, I will.
There's no difficulty.
Yes.
Both the councils appearing for the parties submit that all relevant documents are included in the application and the supplementary affidavit.
I'm grateful. My Lord, by tomorrow, I will be serving to my learned friend.
You prepared it.
My Lord, it has been given for affirmation. That's the main thing.
But it's my document he wants to rely on. There's no difficulty.
It has been relied upon the administration.
It's gone for affirmation.
Milord, I am told, I have not,
It has not been affirmed.
it has not yet affirmed, not yet affirmed.
All relevant documents. The application. Except
Yes,
one document which was placed before the
I'm grateful.
which they seek you to include by way of a supplementary.
Including an RTI reply given by the administration.
Such leave is granted to file supplementary affidavit
I'm grateful.
by yes, 9
I'm grateful.
January 20. This the matter of to availability.
I'm grateful.
Much.
Okay.
Much.
Same.
Both are against the same order.
Yes, same.
We can work together.
Yes.
Absolutely. They need to be heard together.
Yes.
Because the portion that they have lost, they have come up. And the portion that we have lost.
The item number 2. Filed by the writ petitioner.
Writ petitions.
Assailing the self-same judgment and order.
I'll give
Which is challenged by the
give the
High Court in the instant appeal. And therefore, both the appeals shall be heard together.
Grateful.
It is against the judgment and order dated 14 July 2023. Much.
Same order.
Yes, same order. Same order.
So,
Much.
what হয়ে গেছে তো আমরা এইটা জানা অফিস থেকে system. Why we should see for the same case. Next, call the application matter.
Sir, I am for the appellant mode. Sir, I am for the appellant and respondent talking to compromise lawsuit.
Compromise, kind of make it after Gibson.
Effective talking for the purpose of adjournment talking.
No, Lordship.
Yes.
No, compromise talking.
Effective talking or for the purpose of adjournment talking?
Effective.
Effective. What do you want after vacation?
After
After vacation. Not this week.
Lord, I beg to appear for the plaintiff appellant. But I appear for the. Lord, on the earlier occasion, there was direction for sub.
Sir.
My lord, I am for this.
My lord, by dint of the impugned judgment, my lord, my application for probate has been turned down. Against that, my lord, I have preferred an appeal. My lord, application for injunction, my lord. Application for injunction, my lord. Both are brothers, my lord. We are staying in the same property. But my elder brother is threatening me to dispossess me and construct a multi-storied building. That is.
Case of an intestacy, you are one of the.
Yes, I become a co-sharer.
There's no difficulty.
But but he's threatening me to dispossess. That's my kindly takes.
Separate issue. Why in the probate we will bring that?
And he's trying to sell and alienate this property, my lord. And
his share he can sell.
there is no difficulty, but during the situation will become.
Section 44 will come if the stranger purchaser is not entitled to joint possession.
Your lordship would kindly take paragraph 6 and paragraph 7 of my injunction application. Particularly paragraph 7, my lord. Paragraph 7. Midnapur. Proper Midnapur town. Situation will become irreversible, my lord. Well, I have described my possession also in paragraph 6.
Yes, what do you say?
So far the residential property is concerned at plot number 102. The opposite party number 2, my lord, has transferred 3 brothers. One of the brother has transferred his share in my favor by executing a registered deed of gift.
It's another brother. He has at
Yes,
least third.
yes.
Can you throw him out?
No, I certainly not. I am not accepting.
Demolish the structure so that
Certainly not. Certainly not.
he found himself on a bare land.
We are not in a position, my lord. I have no such instruction that my client will demolish or it will transfer. I am in possession. I am enjoying the property.
Yes, kindly records that.
And so far, my lord,
File an affidavit in this regard. Simply saying so.
Yes, I shall. Yes, deeds are with me, my lord. I shall file the affidavit.
Right. Only thing is his right of 1/3.
Yes.
If the probate
Yes.
goes,
Certainly.
And my lord, let the appeal be expedited, my lord.
I can't deny his 1/3 share.
This is an application. From transferring the application for probate is rejected by the transfer.
the photo and taken by trial court, holding that the making and execution of the property will is shrouded by a suspicious circumstance, which according to the appellate is not justifiable. We do not venture to enter into the veracity and the veracity of the at this stage, as the judgment includes presence of the parties and on the records being brought to this court. It is stated in the application that the respondent number 1 is a highly influential people and we use and utilize his resources in evicting the minister from the portion in possession of the joint property, which is denied by the learned advocate appearing for the party. According to him, the father was the owner of the residential house where all the parties used to reside, and in fact the opposite party number 2 has transferred his interest in favor of his client. Be that as it may, it is the council has.
But both are my client. I am appearing for both. Instead of transferring in favor of my client said opposite plan number 1. Because other properties are also there.
Residential house.
Yes, residential house is there.
This is what I've said, residential house.
Yes.
I've not said anything more.
My lord says that it doesn't transfer in favor of my client.
Where
Both are my client.
Both are your client. Okay. My client is one of my.
Yes. I'm with you.
Happy?
Well, otherwise in future maybe some difficulty. Therefore, I am.
No, sit up. Was the owner of the residential house and beside there. Then he submits on instruction that his client has no intention to recover the position from the appellant. In respect of the said residential house, and therefore the allegation in the said application needs to be controverted. Of the above, you feel that the respondent should be given an opportunity. Disclose the stand as disclosed before us in the form of an affidavit, and therefore permit them to file the affidavit opposition within 1 week after the meeting of this court. Reply shall be filed within 1 week. Since the in view of the stand taken by the
another point is there. So for non-residential, the pond and tank of the pond has also been transferred in favor of by us, both of opposite plan number 1 and 2.
But without him?
Ours here.
The deed will reflect the whole of the pond or the share of the pond?
No, share.
That we do not want.
Therefore, I shall file the opposition matter, I shall enclose all.
There is no imminent threat of being evicted from the residential house. Therefore, we need not to pass an entry order at this system. However, liberty is granted to the party to mention the matter in the event any change circumstances has occurred.
My lord, I am for the appellant led by Mr. Van Banerjee. He is
That
in some other court.
Item number 244 on this appeal arises from the land acquisition proceedings initiated under section 18 of Land Acquisition Act 1894. My lord, application, my lord,
Who are you respondent?
I'm for the respondent, my lord.
Whose application is this?
My lord, I was supposed to file affidavit of undertaking, my lord. My lord, let me say on the last occasion, my lord,
What undertaking?
my lord, on the last occasion, my lord permitted me to withdraw the entire decretal amount which has been decretal dues which has been passed by learned civil judge, learned district judge before the learned registrar of this High Court, my lord.
Yes.
My lord, I'm taking steps to withdraw 50% without secret and 50% by furnishing bank guarantee, my lord. My lord, I was supposed to file an affidavit of undertaking that in case the award is varied or set aside or modified, my lord, I shall be liable to pay the excess amount which I have withdrawn, my lord. My lord, that is in process, my lord. In the course of day, that
was supposed to be filed when?
my lord, on the next date, my lord.
So this is the next date.
My lord, it's being affirmed today, my lord.
Why? It was passed on 17th of November. Nearly 1 month has expired. Why you did not file an undertaking? Why you could not file an undertaking?
Kindly extend the time for a day, my lord. Can it keeps up tomorrow in
No,
the first?
not. You will not.
My lord, kindly passes it over within 15 minutes or 20 minutes. It will be affirmed.
No, where? You will give an
No, my lord,
undertaking.
there it is in process, my lord. It's on process.
Come tomorrow. We'll
My
see to it.
lord.
Most of them.
I beg to appear for I appear for the respondent. My lord, the Legal Services Committee has appointed me. My lord, difficulty is this, my lord. Your lordship would kindly takes flag A into consideration, my lord. We are not been able to contact the client, my lord. My lord would kindly directs the DLSA Dhanbad to make an endeavor to contact, my lord.
Your client is living in a Jharkhand.
My lord, my client is in Purulia, my lord.
How she might have made an application before the State Legal Services Office.
No, because my lord, in a earlier order, my lord, I have been communicated by WhatsApp, my lord, just to appoint an advocate. Thereafter, my lord, I just convey, my lord, before this, my lord, this coordinate bench, my lord. And that has been, my lord, canvassed in this previous order. Thereafter, the
Wife has WhatsApp you.
my lord, my lord,
that to engage the lawyer.
my lord, my lord, my lord. Thereafter, I convey this.
Your client, he wants.
No, my lord, because my lord, after servicing this, my lord, this petition, they have contacted me, my lord. And I just, my lord, convey before this lordship that is the communication. Thereafter, my lord, this the erstwhile, my lord, this appointed, my lord, DLSA, my lord, this coordinate bench, my lord, this.
But I made an endeavor. The phone number was given by my learned friend, but unfortunately, I could not.
The number is in existence or?
No, number is in existence, not responding. Number is in existence.
Message,
No, that I have not marked. Then I have to issue. I'll issue a letter.
message or whatever,
But may I issue a letter, my lord?
will not pick up the phone, seeing the.
On repeated occasions, my lord, I tried to call. On repeated occasions, but I do understand.
Not respond because of the unknown number. But at least a WhatsApp or something of that kind, if it is given.
May I take
Or
me?
she has given you message WhatsApp.
My
Could you give a WhatsApp back saying that he has been appointed and this is his phone number contact?
I have been, my lord, communicated from the 2-3 months ago, my lord, just receiving this, my lord, this.
But you have to respond.
My lord, I will, my lord,
Not to him.
Sir, my
You should respond from where you receive the WhatsApp. You said that on your phone call,
my lord,
you received a WhatsApp from the respondent
my lord.
requesting that you please arrange a lawyer for her.
But my lord, I cannot, my lord, take the risk, my lord. That is for appointment. That is why I, my lord, this convey before you this coordinate bench, and my lord, justice, my lord, appointed this DLS.
Unique, like the amount of trust on you, kindly visualize how much the litigant has reposed trust on you. That whoever you will engage as a lawyer, that lawyer will take.
And my lord, when the DLSA had
precautionary measure to protect her interests.
when the DLSA Dhanbad had made
Actually,
an
my lord,
endeavor,
maybe
my lord, she
out
did not
of-
contact them also. My lord will seize the report, my lord, flag it. This is the current position. DLSA has submitted a report before your lordship. She did not revert back to them.
She's there. She has flatly refused to take it.
This is the current position. But I do not have any authority, my lord, to. I might assist your lordship, but without her authority, how can I? My lord will protect me in that regard.
Because I do not know, because she has not approached the
Yes.
Legal Services Committee. For
And a wakalatnama has to be executed in my favor. Will protect me to that, my lord.
Your suit for divorce is dismissed.
My lord. Against that, my lord, this
What
mandamus,
application you have filed?
my lord, applications, my lord, the appeal, my lord, mandamus appeal filed along with the application for condonation of delay. And my condonation of delay has been dismissed for default. And thereafter, my lord, restoration and my lord, section 5 application of the, my lord, first, the section 5, my lord, that is.
An application claim for setting aside the abatement on condonation of delay of period, prescribed period under section 5. Prescribed period under section 5. Admission and appeal.
My lord.
I could not follow this preamble.
Actually, my lord, I just follow, my lord, the
This preambles.
section 5 of this.
Abatement, I do not know on condonation. Abatement means
My lord, actually, the after the statutory time, my lord, over, my lord, I just read out, my lord, this actual word of the section 5 application, section 5 of this, my lord, limitation act. Well, this type of word, my lord, has been written. I think it's section 5. Section 5.
Let us see, sir. Giving you a copy, section 5. Whether this expression words are there in section 5. I do not know. I'm also learning. It's a learning process. So from where you got this? I do not find the language says so.
But I am, my lord, rectified by your lordship, my lord. It is my my lord misconception to just.
Say that you got
My
the
lord.
language from section 5.
My lord.
I was also taken aback because I read many of
No, my lord.
those section 5 language.
No, my lord.
Refresh myself that I have read wrongly.
No.
I have committed a blunder in not remembering that what is the language.
No, my lord. It is I am just enlightened by your lordship, my lord. That is
Then from where you got this language? You said section 5. The brought from agitation, section 5 for setting order of agreement, you have included in section 5.
just for extension of the prescribed period of case.
The delay of more than 1 month day.
Well, that is the appeal, my lord.
Not a condonation. You want a restoration
I have my lord.
of your section 5 application.
My lord.
And which section 5?
একটা মেন্টাল প্রবলেম আছে ওটা রেখেছি কোথায় এটা এসছে
Serve the copy of this application.
my lord,
Show us that you have served this copy of the application. Directly.
না না লাস্ট ওটাও করেছি এই ক্লায়েন্ট কোথা রয়েছে ক্লায়েন্ট কি ডাইরেক্ট সার্ভিস ওটাই
No, if you have served upon him, what about the client directly?
এই ডাইরেক্টলি করা হয়েছে my lord, as per my learned friend, my lord, this is my lord the earlier kept on record. Earlier affidavit of service, my lord, kindly may I
Serve a notice that this matter will be listed on 17th January.
directly do that,
Directly.
my lord. Your lordship would
Submits that is appointed by High Court Legal Services Committee to represent the responsibility. But he has made all attempt to contact the
we contact her, but she is neither responding to his call nor have reverted back. Therefore, showed his inability to proceed with the instant matter. It appears that the appointment of Mr. Banerjee was made on the submission of the learned advocate appearing for the appellant that he has received a WhatsApp message requesting to engage a lawyer for her. In such scenario, there is no in such scenario, Mr. Banerjee showed his inability to represent the respondent in absence of Mr. That is by execution of a Bhagavata. We feel that the respondent is entitled to notice before we proceed to decide the applications. We therefore direct the applicant to serve a notice to the respondent that this applications can be listed on 17th May, 17th January 2000. It should be indicating letter that in absence of her appearing before this court, the matter may be proceeded expunged.
But I will also, my lord, contact my lord client whether any other my lord proceedings has been pending or not from that. If my lord, my lord.
Next.
Because I appear for the plaintiff respondent number 1 and 2.
Which I appear on behalf of the appellant, so I'll have to seek an accommodation as now, Your Lordship, the appellant, Your Lordship, is Twitter, which has now been taken over by Miss Lordship.
It is now been
Taken over by X, yes, Your Lordship. Yes, Your Lordship. So I'll have to carry out an amendment, and Your Lordship,
after vacation.
grateful, Your
So
Lordship.
I am suffering, my lord. My suit virtually cannot proceed because of this, and they have made this submission at least 8 months back. That they will have to carry out this amendment because this thing has happened at least 6 months back.
Lordship, we have carried out an amendment in the lower court, and we are not hindering the process in the lower court. The lower court is proceeding. We have.
I cannot proceed. Look, this is a John Doe action, and by way of an interim order, the direction of the trial court that they will have to disclose the name of the user has been stayed.
Lordship, this application for substitution has been sent.
We left with 2-3 days. If we have waited for such a long time, there's a
Very
last.
well. Lordship.
It will appear on 2nd. If you do not, then
Very well, Your Lordship. Lordship, it's already sent to the US for notary and
the
apostille.
injunction has been granted in a John Doe proceeding.
Yes, Your Lordship.
So far as publication and distribution on the social media is concerned, that has been injuncted along with an order that they will have to disclose the name of the user. Facebook and Instagram have complied. Twitter has come up before you.
Why not in the name of Ashok Kumar? Why John Doe?
Ashok Kumar, in the name of Ashok Kumar only.
It's in the name of Ashok Kumar.
Why we borrow those European and the American?
But in India, there is no female reference to Ashok Kumar. Like in foreign concept, we have Jane Doe for a female user. But in India, we carry out Ashok Kumar for both male and female users.
There is no difficulty in Ashika Kumari.
Yes. I'm grateful, Millet.
Grateful, Your Lordship.
Let us take up further matters tomorrow. So today, administrative meeting was there that continued. So, on this matter.